Alrighty everyone, you'll have to forgive me. I am way behind on my property podcast episodes. I've been working on my outline. My property outline is finally up to date. But I have not done podcast episodes on property, I think, in over a month. And so we're going back into some information that I'm going to have to recall. There's just no way to get around that. Ultimately, I'm going to be not exactly reading from my notes. A lot of this is also going to be from memory. But notes are going to be very supplemental in helping me to recall this information so that I can hear it and review it at a later date in preparation for the final exam. The plus side, I feel really confident in nearly all of this material. The downside, there's one thing that I am not confident in when it comes to this material, and that is the recording acts. That'll be a few episodes down the road, I believe. But in this episode, we're talking about transferring the tenant's interest. If you remember from what we just left off with last time we talked about a property, we're talking on leases, and then we were focusing on the conditions of the premises. And now we're still focusing on leases, but now we're talking about transferring the tenant's interest, because the tenant does have an interest, a property interest to that, a valuable interest to that property. We're talking about transferring that interest to another person. And there are two ways to do this. You can either assign that lease or you could sublease. So now really the real question is the transfer an assignment or a sublease? And it's important to get that distinction right. What makes an assignment, what makes a sublease, because if you don't get that right, ultimately it shapes who's liable if there's any issues that arises with the lease. So leases are interesting. They are a combination of contract and property law. When you enter into a lease, you're entering into a contract, which imposes duties based on that contract. But there is privity by estate, meaning you did a purchase between two bona fide purchasers, and those outline relationships that landlords and tenants have specifically based on property law. And that's a big takeaway from Ernst versus Conduit, which I won't get into the facts. Quite frankly, I can't really remember the facts. But it introduces this idea, and I've already mentioned it, is the difference between a privity of estate and a privity of contract. And this is important to realize because privity of estate and contract are different for an assignment and for a sublease, because there's privity between certain parties when it comes to an assignment and when it comes to a sublease. So under an assignment, the original tenant can be liable for any damages that have be under privity of contract, and the assignee, that's the person who is taking the lease, is liable under privity of estate. Okay, so what do I mean with that? Let's go ahead, just pause and talk about this. Let's say a tenant wants to move from their property. They talk to their landlord. The landlord says it's okay. What are you going to do? Well, I'm going to give the remainder of my lease because there's time left. I don't want to pay it. So I'm going to give this remainder to a third party. And this third party is going to make payments. They're going to live here, or they're going to use the premises for whatever is appropriate underneath the terms of the lease. And that person is either going to be called an assignee or a sublessee. Now, for an assignment, I had just mentioned that there's privity of contract between the landlord and the tenant, and then there's also privity of contract between the tenant and the assignee. It's important to note that there is now a privity of estate between the landlord and assignee. How is this different from a sublease? Well, a sublease, the landlord has privity of contract and privity of estate only with the tenant, and then the tenant has privity of contract and privity of estate only with the sublessee. So what's that mean for the tenant, the original tenant? Well, underneath as an assignment, the tenant may be liable for breach of contract, but they are not liable because of privity of estate if the assignee chooses to ignore something. But underneath a sublease, the tenant may be liable for the actions of the sublessee because the landlord is only has privity with the tenant, meaning that they can recover with the tenant anytime for the actions of the sublessee. So I went ahead and just talked a whole lot there. Let me go ahead and some of this might be a repeat from my notes, but I'm going to go ahead and just pretty much read it. So, how do we determine if the transfer is an assignment or a sublease? The language in the contract is not deterministic, and instead you're going to evaluate the intent of the parties who wanted the transfer to occur. What's that mean? Well, if the original tenant... what's it mean if the language is not deterministic? Well, a party can say, I want this to be... in the language of the transfer, it could say, Party 1 assigns, sublesses, etc. to Party B. Well, that doesn't tell whether or not it's an assignee or a sublessee. And even if you specified which one or the other, that is not deterministic. Now, how do you determine? Instead, you're going to look at the transferred interest. So, if the original tenant transfers all their possession for the remaining of the lease term, the transfer is going to be an assignment. But if the original tenant transfers less than what they have, keeping a reversion, the transfer is going to be a sublease. So, for example, say the tenant wants to move away for the summer, but they want to come back at the end of the summer. Well, they find a third party who's willing to take the lease for the summer. That person is going to be a sublessee, and this is going to be a sublease because the tenant plans on coming back at the end of the summer before the lease has expired. That would be a good example. Our second case that we had was Kendall versus Ernst Pistana Inc. And our big takeaway from this case is that although a lease can usually be transferred freely without any issues at all, many leases are going to have clauses that limit the ability to transfer. And there are three main types of these clauses. You have the sole discretion clause, which says that the landlord can deny the transfer for any reason at all. You've got the reasonable clause, which means that any denial must be for a commercially reasonable reason. And then you have the silent consent clause, and that's if the clause doesn't articulate the standard for a refusal. And the issue that came up in Kendall is that there was a silent consent clause. It didn't say whether there was a commercial reasonableness standard or if it was a sole discretion standard. So the court needs to say, well, what's going to be the case if they're silent about this? What's going to be the outcome? And the court, at least in California, determined that the default should be a reasonable clause when there is a silent consent clause. So in reality, there's only two. You've got sole discretion or you've got reasonableness. And if it's silent, then you're going to go back to a reasonableness standard. And that's our big takeaways from transferring the tenant's interest. It's a short period, a short amount of notes, but I spent a lot of time on it. Just to summarize, you have privity of estate and privity of contract. For an assignment, you've got landlord who has privity of estate with the assignee. For a sublease, you've got privity of estate only with the tenant, and the tenant has privity of estate with the sublessee. As for the assignment, you've got privity of contract between the landlord and the tenant, and then the tenant and the assignee. For the sublease, again, you've got privity of contract between the landlord and the tenant and the sublessee. No change there. To determine whether or not it's an assignment or a sublease, you're just going to look to see if the original tenant kept any interest for themselves. If they did, then it's a sublease. If they didn't, it's an assignment. And then if the landlord wants to limit the ability to transfer, and they need to add in three different types of clauses, whether it's sole discretion, reasonableness, or just remaining silent. In that case, the default is going to be reasonableness. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.